Welcome back, Love Nation. This is Nina. Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. You guys, there has been so many updates with this Blake Lively, Justin B. It Ends With Us movie situation. It is so many moving parts, and I love to read through lawsuits. I love to read through the filings. I love to get to every single part of what is going on for you guys. And there has been so many things filed with this case concerning, various viewpoints, who said what, who did what, what's on video, what they believe happened, what they believe didn't happen. It is so hard to actually read through 50 to 100 filings a day and try to get these filings out to you guys in a order for which it should be in. And I do apologize. I did take a break. I will be coming back now to try to read through all of this mess, because when I say that these guys have been coming with receipts, they have been coming with receipts. Now, this one pertains to Justin B's team, and it is responding to Blake Lively's motion to withdraw from this lawsuit. And again, it's 45 pages. There's a lot going on, and this is part one. And again, there is a lot of mess to be had with this situation. A lot of things have developed, which I will actually be making videos for. Bear with me in patience as I try to catch up on some of this tea with the It Ends With Us lawsuit. It is way beyond a mess at this point. And again, this is part one. Consolidated Plaintiffs, Wayfair Studios, Justin B., Jamie Heath, It Ends With Us Movie, LLC, IEWU, Melissa Nathan, Jennifer Abel, and Steven Sorowitz, collectively the Wayfair parties, respectfully submit this memorandum of law in opposition to Consolidated Defendant Blake Lively's motion to dismiss the amended complaint for failure to state a claim for attorney's fees, costs, damages, and punitive damages, and to strike Exhibit A of the amended complaint, pursuant to Federal Rule of Civil Procedure 12B6 and F and California Civil Code Section 47.1. The motion. Memorandum of Points and Authorities. Section 1. Introduction. The first amended complaint, FAC, contains hundreds of pages rife with factual detail about Blake Lively's calculated efforts first to extort and manipulate the Wayfair parties into ceding total control over the film It Ends With Us, and then to defame and scapegoat them when her plan backfired. Nevertheless, Blake Lively refuses to accept responsibility for the trail of untold destruction she left in her wake. But she goes further still. Blake Lively asks the court not only to dismiss the AFC, but also to award her attorney fees, costs, treble, and punitive damages for the Wayfair parties' constitutionally protected act of petitioning the court for redress of their grievances. In essence, Blake Lively asked the court to find that she is immune from any culpability for her wrongful acts, and instead it is the Wayfarers parties who must be punished for daring to exercise their constitutional right to seek a remedy from the courts for her lies. The motion must be denied. The FAC specifically alleges abundant facts in support of the Wayfair party's claims against Blake Lively, based both on her own direct actions and on those of her co-conspirators and agents. The Wayfarer parties have pleaded allegations against Blake Lively sufficient to defeat dismissal, and Blake Lively's arguments often border on frivolous. In particular, Blake Lively's argument, excuse me, that the California Civil Code Section 47.1 immunizes her from liability, which will require the court to determine as a matter of law that she acted alone and without malice, and that she had reasonable basis for her claims. In other words, to make findings of disputed fact not appearing on the face of the pleadings, which flies in the face of well-established rules governing motions brought under Rule 12bc. When the court assumes the truth of the facts set forth in the FAC, as it must in ruling on this motion, the only possible result is the denial of the motion in full, regardless of any technical defects or instances of inartful pleading in the FAC can be readily cured by amendment, which is freely allowed, and the Wayfarer parties are every day obtaining facts to plead in support of each of their claims against Blake Lively. Furthermore, the Wayfarer parties can amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. Finally, even in extremely unlikely events that the court determines that dismissal without leave to amend is appropriate, Blake Lively is still not entitled to the award of fees, costs, treble damages, and punitive damages that she seeks. The draconian one-sided sanctions that Blake Lively demands under California Civil Code 47.1b are, in a matter of first impression, barred by the no error Pennington doctrine, which precludes the imposition of liability for the exercise of rights protected by the Petitions Clause of the First Amendment. The First Amendment protects the right to petition the government for a redress of grievance. In other words, the Constitution safeguards Americans' rights to ask the government to take action, such as by bringing legal claims. The no-error Pennington doctrine bars courts from punishing litigants for bringing good faith claims, including through the imposition of harsh penalties like the treble damages award Blake Lively seeks here. Because the Wayfarer parties have brought the good faith claims against Blake Lively that are neither objectionable, baseless, nor subjectionally brought for improper purposes, the First Amendment protects them from being punished for the act of seeking relief from this court. In short, the motion must be denied or at most granted with leave to amend. In no event on the motion or at any stage of these proceedings will the First Amendment permit the extreme and unconstitutional award of fees, costs, and trouble, and punitive damages Blake Lively demands. Section 2. Legal standing and factual background. Pursuant to Federal Rule of Civil Procedure 10C, the Wayfarer parties incorporate by reference their allegations in the FAC, docket number 50, and the recitations of legal standards, and factual backgrounds in opposition of the Rule 12bc, motions of consolidated defendants Leslie Sloan and Vision PR Incorporated, together the Sloan parties, docket number 121, the New York Times Company, NYT, docket 127, and Ryan Reynolds, docket number 160. Blake Lively and the Wayfarer parties agree that the California law applies to their claims. Motion at 10-11. I am going to end part 1 right here. Please stand by shortly for part 2. Like, share, subscribe if you have not done so. This case has a lot of moving parts. This particular filing, I do believe, could stand to either keep this case going or dismiss in a very vital way that could derail this case for Justin B. So I am definitely going to read through this one in particular as we await the judge ruling. In the meanwhile, like, share, subscribe. Be patient. Part 2 is coming very shortly. And again, Love Nation, share your comments below. Until next time, be safe. Enjoy your day. Bye, guys.